and they put us in a very good position to begin a conversation on the themes that they've introduced in their two presentations. And Dr. Lee is going to kick that conversation off. So if I can invite him to the podium to give his comments and questions to the two speakers.
Thank you very much, Moderator. I'm Dr. Wonhee Kim, working at the Korea Institute of Ocean Science and Technology. It has also Ocean Law and Policy Institute, so that's why I'm working here. And first of all, I would like to express my sincere gratitude to the organizers, 3 of organizers, and also many wonderful presenters, and also a very good friend of mine, Moderator. So I really learned a lot, and it was a very insightful and informative presentation. As I discussed, that there were many variety of laws as a discussion, but I'd like to raise some question to each speakers. My first question, my first part of question goes to Larry. So Larry also quoted the very famous phrase by the Louis Henkin. I'd like to remind you of the exact phrase. Almost all nations observe almost all principles of international law and almost all of their obligation, almost all of the time. I got some impression that he got some class of the English poetry or something like that. So from your presentation, I learned that it is still true that most of the countries are observe the international law almost all of time and their obligation. But do you think, I'd like to ask this question but there are many high-profile cases you mentioned. There were non-compliance cases involved by the permanent members of the Security Council. So when we're talking about the success or assessment of the success of the UNCLOS, we are just mentioning the failure story, not the successful story. So my first question is that, which do you think is the most successful story of the litigation under the UNCLOS compulsory dispute settlement? It's my first question. So I think we need to spread out good news than the bad news, because many media, especially Western media, only are interested in the bad news and non-compliance of international law, and they are attacking very pessimistic about the international law and whole system of the UNCLOS. So I'd like to ask the first question. And my second question is getting a little bit specific. So you also explained about the non-appearance cases. So Arctic Sunrise and South China Sea case. I think that China has learned the strategy from the United States in the Nicaragua case. So it is very well-known story. So my question is that I think the compliance, there are many factors which can affect or impact upon the compliance of the states after the judgment. So I think one of them is the procedural justice. So the international dispute settlement procedure is based on the consensual jurisdiction system. So if one of the parties is absent from the international procedure, then it could be directly impact upon the compliance or implementation of the judgment. So how do you evaluate the non-appearance? Do you think is there any direct bearing upon the non-appearance and with the non-compliance of the judgment? And also, do you agree with that kind of statement that guaranteeing the procedural justice and equality of arms could be play an important role to make states implement and comply with the final judgment? So it's my second question about the non-appearance. My third question is about some tendency of expanding the jurisdiction under the Part 15 of the UNCLOS. After the South China Sea Arbitral Award, there were many commentators, academics, and also practitioners criticizing that the tribunal have expanded the scope and limitation of the jurisdiction under the Part 15. I totally understand, because there were many issues involved in, like a so-called mixed dispute, territorial issues, and maritime boundary delimitation, and an obligation to protect and preserve the marine environment, something like that. So, however, when we consider the early jurisprudence of the PCIJ and ICJ, when they were talking about the political dispute and legal dispute, so they made some distinction between the political dispute and legal dispute, so they were very restrained on exercising jurisdiction over the political dispute. But as time goes by now, it is very difficult to find out such a kind of approach before the International Court of Justice, not only the ICJ, but also ICLOS or arbitral tribunal. So is it fair to evaluate this tendency of the International Court and Tribunal as the expanding their jurisdiction, or they are adapting to the new environment of international society regarding the solving or peaceful settlement of international dispute? I'm sorry for too many questions. This is third question. And my first question is about the criteria for assessing the effectiveness of the peaceful dispute settlement procedure and regime of the UNCLOS. So you just showed us that around 10% of the non-compliance cases we found, so 90% of cases were complied and also implemented by the contending parties. I think that it's a kind of a qualitative approach about the implementation case. But how do you think, how can we make on some criteria to assess the qualitative factors of the implementation of the judgment? So, for example, after the South China Sea Arbitral Award, the President Xi Jinping and Duterte made some summit meeting right after the arbitral award, and they made a lot of the arrangement, bilateral arrangement. The Philippines got a lot of the investment from China after the award, and also China lifted a little bit. China was prohibited the Philippine fishermen coming to near the Scarborough Shoal. It was a very rich fishing ground. But after the award, China also lifted up. They allowed some limited access to the Scarborough Shoal as well. So I think we need to invent or think about the criteria of assessing the effectiveness of the compliance and also dispute settlement mechanism. This is end of my question. And second part, please have understanding, we lost Penelope, so I got some confirmation from the organizer. You can use your time enough, so please have understanding. So I'd like to ask Douglas about a very, very interesting presentation. I remember that the former Judge Jessup also a very famous quote, "There is no dichotomy between law and diplomacy." So I think before there was some kind of time gaps between the domestic politics and international politics. But nowadays, when we look at the Ukraine crisis or South China Sea issue, the domestic politics is directly affecting the international scene. So I think your presentation is very timely, and also your research project will contribute to understand the whole situation, the whole scenery of the interplay between the law and politics and law and diplomacy. So my first question is that you mentioned that the political misuse of international law. So, but you also mentioned that the state is itself as a political institution. So according to your quote, so it's a similar question to you. So how do you evaluate the political dispute also involve the legal issues almost every time? Not only the Chagos cases, but also Australia and Timor-Leste maritime boundary delimitation dispute. Everything is relating to the law and politics. So how do you make some distinction between justiciable case and non-justiciable dispute based on the political dispute and legal dispute. It's my first question, is very similar to you. And my second question is that, to be fair to Sir Michael Wood, so I would like to remind the case, a very successful story of the UNCLOS dispute settlement between Australia and Timor-Leste. So Timor-Leste made all the alternatives to solve the dispute on the Timor Gap Treaty, some disputes, maritime boundary delimitation, also joint development issue with Australia. And on the contrary, at first Australia was very vehemently opposed and reject the negotiation. And also they sent on some special agent to their legal counsel office, and also it brought the ICJ proceeding, and also it finally at the end of the day, you should have used the compulsory conciliation procedure. So I'd like to ask you this question: how the international law was affecting the change of the Australian government towards the Timor Sea Gap Treaty and joint development issue? Because at first it was very strong position, and also it was very offendable to the Timor-Leste at first. But as time goes by, the Australian government has changed their attitude. So I'd like to ask some detail on the process of the impact of international law and UNCLOS dispute settlement mechanism to the change of the Australian government position. My third question is about the role of the legal advisors in dealing with the legal and political disputes. So when we recall that the Chagos dispute began by the declaration of the MPA near the Chagos Island. David Miliband, the former Secretary of Foreign and Commonwealth Office, he just ignored the legal advisors. Most of the legal advisors do not proclaim the MPA at the time. So how do you think in most cases, the legal advisors giving the advice do not do that to the political decisions? So what should be the role of the legal advisors in that such a very sensitive issue? And also, how can we persuade the decision maker not to do that, violating international law? And my last question is a legal effect of the Chagos advisory opinion. So when we recall the preliminary objection judgment by the special chamber of the ICLOS on the Mauritius and Maldives maritime delimitation case, the special tribunal made us very sensitive wording about the legal effect of advisory opinion. So it is, to some extent, so I can understand, it's not legally binding. The advisory opinion of the ICJ on the Chagos Archipelago is not legally binding. It's okay. It's perfectly understandable. But what is the legal effect given to the advisory opinion? So this is my guess. Mohammed Shahabuddin, the former ICJ judge, wrote about the precedent in the World Court, and he pointed out that the legal binding effect, the judgment of the ICJ, is only legally binding between the contending parties. That's because the dispute settlement mechanism is based on the consensual jurisdictional basis, not just ignoring the legal ramification of implication of the ICJ judgment. So I'm looking for some clue from that kind of statement, but how do you evaluate the finding in the special chamber about the using the legal, they gave the deference, very big deference to the legal effect of the advisory opinion of the ICJ. So this is my last question. Thank you very much for your patience. You don't have to answer all the questions. Thank you.
Thank you very much, Dr. Kim. And apologies, my 5 a.m. brain got your name wrong just a second ago, so very sorry, Wonhee. Mr. Martin, do you want to respond to those comments and questions first?
I'll do my best. Thank you, Wonhee, for those very straightforward, easy to answer questions. On your first question, relating to celebrating good news and not emphasizing bad news, I mean, the reality is I agree with you in large measure. I think Part 15 in promise and in reality has largely been a success. If you simply look at the numbers, right, let's just call it 90% of the time, plus or minus, judgments and awards are being respected. That's a remarkable achievement, especially for a worldwide treaty like this. And I don't want to do anything to diminish it. I just wanted to point out that in my mind, there are causes for potential concern, right? It remains to be seen whether these are isolated instances that are the result of the individual circumstances in those cases, or whether this is more of a trend, quote unquote, that may develop further in the future. That remains to be seen. I'm hopeful, but I'm also concerned. You asked me what the most successful case has been so far. That's hard, but I guess the first most direct answer that comes to mind is the Bangladesh-India maritime delimitation case. And that case was heard before an Annex 7 tribunal. And the reason I say that is just given the power dynamics at issue in that case between Bangladesh as applicant and India as respondent. It had the potential to be quite problematic. Bangladesh is not only a comparatively smaller, comparatively weaker, even more in development country, it is also heavily reliant on India in many ways. So there was the potential there for India to either flout the process or flout the award. But notwithstanding the fact that I would, maybe I'm prejudiced here as one of Bangladesh's counsel, but notwithstanding the fact that Bangladesh achieved a pretty remarkable result, India accepted it, behaved precisely, frankly, as you would want a quote-unquote losing state to behave, and has accepted and implemented the judgment. And I just think that's a really good example, the one that comes first to mind, because there was potential for a different outcome, a different reality. On the second question you asked about non-appearance and whether it's related at all to non-compliance, I mean, I think the facts speak to there being a very direct correlation. If somebody's not going to appear, it seems to me that the chances are substantially higher that they're also not going to comply, in part because I think not appearing is one initial step of trying to deny the process of any legitimacy, or at least maintaining the argument that the process was not legitimate. So it's not surprising that the two instances we talked about of non-compliance subsequently evolved into also two instances of non-compliance. And I guess I'll repeat what I said during my comments earlier. It makes life very difficult for courts and tribunals when that happens. And in the international system, of course, courts and tribunals are always very, very mindful of the need to ensure procedural equality, equality of arms, both in every possible sense. But I think South China Sea, for example, is a great case where the tribunal really bent over backwards to not only maintain the appearance of procedural fairness, but really, really protect the reality of procedural fairness. I mean, the number of steps that the tribunal took, extraordinary steps that it took in light of, or to deal with the fact of China's non-appearance was quite remarkable. After the Philippines submitted its memorial, Philippines was given a list, I think it was 26 or so questions from the tribunal that needed to be addressed in writing. These went both to jurisdiction and the merits, and on the merits it went to the law and the facts. I mean, the tribunal delivered an exhaustive list of questions, I think precisely to establish the record that it had been scrupulously fair. It then bifurcated the proceedings into a separate jurisdictional and merits phase, first to deal separately with the issue of jurisdiction, and only then, if there was jurisdiction, to the merits. Before both hearings, the tribunal issued a long list of questions that it wanted the Philippines to address, again, precisely to ensure that there could be no meaningful argument that, procedurally speaking, fairness had been denied, which of course is a way of trying to insulate the merits of any decision from a form of attack. On the issue of whether there's a tendency to adopt a more expansive approach to jurisdiction, I know that criticism is out there. I generally don't agree with it. I can see some of the points that critics make, in particular about ICLOS and Annex 7 tribunals, but I really very much disagree. So, you know, you pointed out yourself to two examples of decisions, or two decisions that are the subject of a lot of criticism: the special chamber decision in the recent Maldives-Mauritius case, the South China Sea case, the advisory opinion decision of ICLOS, in which it found that it had the authority to consider, general authority to consider advisory opinions, has also been the subject of a great deal of criticism. I guess I take a different view on that issue. In my experience and in my opinion, the pure law of the sea tribunals, if you will, as contrasted with the ICJ, are much more willing, much more able to just answer clear legal decisions that are much less influenced by politics. I hope we don't have any colleagues from the ICJ in the audience, but if we do, I apologize in advance. In my personal opinion, the ICJ has a tendency to be far, and maybe by necessity, so I am sympathetic to that, but it has the decision to be far, the tendency to be far too political in the way it makes decisions. Even its most legal decisions are, in many cases, very obviously affected by politics. In contrast, I think, again, the quote-unquote pure law of the sea tribunals are much more willing to look at an issue and decide it as they think is right according to the law in a more purely legal framework. So, I mean, I'm very aware of that criticism, but I don't share it, to be honest. I think it actually speaks to a greater courage, if you will, to disregard politics in matters of law, if one can separate them. I think your last question, for me anyway, was sort of the criteria to assess compliance. I confess, Wonhee, that's way above my pay grade. I'm just a, practicing lawyer. I don't think such deep thoughts, but I'd love to hear Professor GUILFOYLE's thoughts on that. But I mean, it seems to me the simple answer is just comparing the award, the dispositif in an award or judgment, and subsequent action. And the extent to which they align is the extent to which you determine compliance. Which I guess is one of the reasons why I characterize the Arctic Sunrise as an example of soft non-compliance or soft compliance, whichever you want to say, because again, if you do that comparison, you see that at the end of the day, what Russia was ordered to do and what it actually did were very similar, if not precisely the same, in terms of the monetary settlement ultimately. Just one quick observation before I forget. I mean, in my mind, the behavior of Australia in the Timor-Leste conciliation is precisely what you should expect from any state in these matters. Yes, it vociferously objected to jurisdiction, and I think it may have had good grounds to object to jurisdiction. And that's entirely its right. Every state has the right to make its arguments in the strongest form it chooses to make them. But it also has to accept the fact that it doesn't get to decide on its own position, that that's the job of the tribunal. And so when Australia, notwithstanding the strength of its objection, accepted the result and then proceeded to engage fully and in a very collaborative fashion with the conciliation panel, I think that too is a huge success for the system. So I guess coming full circle to successes, I would rank that up there with the Bangladesh-India case as a wonderful example of the good that can be done through the system. Thanks.
Thank you very much.
Okay, yes, the microphone seems to be working. There's a phrase in Australian English, the hospital pass, which means when you're playing sport and a good thing happens to you, you're past the ball, but under circumstances where you're tackled so violently, you go to hospital. So I'd like to thank both Wonhee and Lawrence for their hospital pass in terms of the questions I've been given. So on your first question, Wonhee, essentially I think it boils down to how do we identify which disputes are non-justiciable because they're essentially political? And my answer would be there is no such category, right? Disputes are non-justiciable because they don't fall within the legal authority of the decision-making body. It's a legal question. And I can't think of a case post-Nicaragua where a court or tribunal, but someone can correct me if I'm wrong, where a court or tribunal has heard the argument this dispute has an essentially political character and denied jurisdiction on that ground. They might have denied it on another ground, but the idea that a dispute should not be heard because it has political features isn't one that's found favour with a court or tribunal I can recall recently. And I think that's for the fairly obvious reason that why would a state litigate a matter that is not in the national interest? Why would a state litigate a matter that had no political impact or that had no pressing reason to do so in national politics? The only kind of exception I can think of potentially purely altruistic involvement in litigation is the very high number of interventions we're seeing at the ICJ at the moment in proceedings concerning the Genocide Convention. Which I suppose also goes to the question you posed, Lawrence, about, is there an expansion of jurisdiction under Part 15? And I can see that criticism as well, but I think that goes to the nature of Part 15. Everything in UNCLOS was a compromise, and the question is, how do we read the compromise? So you can read a lot of accounts of Part 15 which say Part 15 was intended to be very narrow, and we know that because it has so many exceptions. But if you read accounts from the time from Group of 77 negotiators, they wanted a very comprehensive Part 15, which, on its face it is. And if one takes that as kind of one's guiding consideration, one would say one should read the exceptions very narrowly rather than very widely. So I guess what I'm saying is, to some extent, you know, that the scope of jurisdiction will naturally fluctuate over time, depending kind of the reading one takes of the underlying purposes of UNCLOS and the compromises it embodies. Australia, Timor-Leste. So the question was, how did international law affect the Australian government's change in position? I think I'd first start by sort of saying, as lawyers, we can sometimes be a little myopic. There was a lot of work done in general Australian community consciousness, both by the East Timorese and also those sympathetic to them. And I think there was a growing body of opinion that we weren't behaving honourably towards a very close and much poorer neighbour. But I do think significant pressure was placed on the government of the day by multiple related ICJ proceedings, which goes to the kind of point I was making before about how legal proceedings can apply pressure to politics. And obviously one of the things the conciliators did that was very useful was to say, okay, how do we get the parties to as close to tabula rasa as possible? And part of that involved East Timor giving up its, or discontinuing its ICJ proceedings. So that, in a sense, gave them a bargaining chip to help both bring Australia to the conciliation table and proceed from there. Also, I'd say overall, I think the conciliation's a great success story at many levels, but it also, I think, did a lot to restore Australia's reputation in the region. And yes, Australia vigorously contested jurisdiction, but having lost that point as a state that holds itself to the rule of law in international affairs, went through with the rest of the conciliation. And that was very favourably received. And I think that goes again to my sort of thesis about legitimacy. Australia restored a lot of its legitimacy in the region through doing the honourable thing in the end in the conciliation. Although I think our relations with East Timor are a little bit like what Winston Churchill was meant to have said about the United States. You know, we did the right thing, having exhausted all the other options. Then your question about the role of legal advisors essentially was, how do we persuade politicians to follow the law? I think there are other people in the room who are vastly more qualified to speak to that question than me, but I suspect a number of them might answer, when you work out how, please tell me. I think all we can do when advising anyone on the law is to say, well, you know, this is what I believe the law to be, these are your possible courses of action, and these are the consequences if you ignore the law, which in the international realm might often be questions of reputation and legitimacy. Right, then you asked me the sort of $5,000 question, how do we explain the precise legal effect of ICJ advisory opinions and the conclusions of the ICLOS Special Chamber? I think it was the late Robbie Jennings who said that any government that stands on the position that advisory opinions are completely distinct and have no legal effect compared to contentious decisions of the ICJ is going to be disappointed and going to have a very difficult time making that argument. And that was a purely pragmatic point. But I think we can take that pragmatism and ask, what would the effect have been for the tribunal to say we cannot take the advisory opinion into account at all, or worse, to say we acknowledge that the advisory opinion tells us this is an illegal situation, but the very fact of that illegality means we can't take jurisdiction? What position would that have put the tribunal in? And my contention would be it would have put the tribunal in an untenable position. So the difficulty we've got is that as lawyers, it's very easy to critique things, and often it's much harder to build them. So that the problem, I think, for the special chamber was perhaps a classic hard case making bad law, right? The conclusion, in a sense, was obvious, and doing anything else would be inconceivable, but justifying it on the basis of the existing law was very difficult. The question about measuring compliance was passed to me. That was a particular hospital pass. All I'll say is that a friend of this conference, Professor Natalie Klein, has been working recently on a major review of compliance with UNCLOS decisions along with Jack McCaffrey. And their analysis, once they'd developed criteria and broken the cases down into different categories, I think presently sits at about 50,000 words. And we can expect that, I suppose, to come out either as a very long article or a very short book in due course. and I'll just commend that to everyone's attention once it's published. If we do have time to go to general questions, to the extent I've been provocative, I just say that early in my career, someone present in the audience who I won't name heard me give a talk where I said some very provocative, in retrospect, a couple of slightly silly things, and they very politely said, well, that was very interesting, but I don't believe a word of it. So I'd be perfectly happy with that feedback on anything I've said today. James?
Thank you very much, Douglas. And yes, we do have time for at least one round of audience questions, and I very much welcome that. I am in the strange situation of not being able to see the audience, so I'm going to have to rely on my panel members to facilitate this somewhat. I'm actually going to abuse the chair a little bit. I have one question for each of the presenters that I will ask, and then I will, if there are hands in the air, I will maybe ask Wonhee if you could kind of select people, and we'll get those questions. So my question for Larry is, you mentioned enforcement during your presentation very briefly. And what was interesting for me is that two of the cases you talked about were ICJ cases, which obviously is one of the few tribunals to have some sort of enforcement compliance mechanism built in by way of reference to the Security Council. And I just wonder what your views on that as a practical, feasible mechanism to oversee compliance with judgments is, given it's not been used in either of these cases as far as I'm aware. Yet they are two cases where they are small states, they're not P5 members, which has been the biggest problem in the past of using that. Whether you have any reflections on that. My question for you, Douglas, would be whether your framework for analysis is limited to small powers versus greater powers, or whether actually it has a wider application beyond that to even medium powers versus medium powers as well, or whether there's something particular about that pairing that fits that particular analysis. Do we have any hands in the air?
Professor Donald Loswell, please.
Thank you. Donald Rothwell from the ANU College of Law, Australian National University. I have a question for each one of our colleagues on the podium. Larry, I wonder if I could get you to switch to Douglas Guilfoyle mode and give us a political analysis as to whether or not you think in the case of Nicaragua, Colombia and Somalia, Kenya, there were any particular domestic political issues at play which may account for the way in which the two non-compliant states responded to those ICJ decisions. Douglas, we have inadvertently commenced the discussion in this panel about the conciliation between Australia and Timor-Leste. I'm wondering, Douglas, because you mentioned it not only in your comments, but you've also indicated that it's part of your research project, what influence do you think the award in South China Sea and China's reaction to South China Sea may have played for Australia in terms of the very active engagement Australia had in the conciliation process, and especially following its loss in the award on competence before the Conciliation Commission, Australia's engagement with the Conciliation Commission to reach what I certainly saw was a completely remarkable outcome given the background to those issues between Australia and Timor-Leste. I think for the benefit of those in the audience, there was a very significant level of commentary within Australia that you've alluded to, Douglas, that Australia had acted in bad faith for many years with respect to Timor-Leste, but that there is this view that's been drawn that Australia could hardly criticise China for its position in terms of responding to South China Sea, but then perhaps effectively walk away from the conciliation with Timor-Leste. And my friend Dr. Kim, can I just ask you, for the benefit of those who are not from Korea, if you could give us perhaps a Korean perspective and insight into some of the issues that Larry has raised in terms of non-compliance and non-appearance. What is the position in terms of, I won't ask you to speak on behalf of the Korean government, but the Korean scholarly community in terms of how you view some of these really important issues that Larry's identified in terms of Part 15 dispute resolution mechanisms? Thank you.
I would suggest we gather maybe 2 more questions and then we can, if there are 2 more questions.
From the floor?
From the floor. Are there any more?
No questions?
No? Okay, in that case, Larry, do you want to respond first?
Sure, happy to. On your question, James, about enforcement of the Nicaragua, Colombia, and Somalia, Kenya cases, it's and whether it's practical and feasible, I think the short answer is with respect to the Colombia-Nicaragua case, no. And then with respect to Somalia, Kenya, it remains to be seen. And the reason for those 2 different answers is just determined by international politics. In the case of Nicaragua, Colombia, I think there's precisely 0 chance for the foreseeable future anyway, that any enforcement effort would have a chance even of succeeding for 2 related reasons. Colombia is an important ally of the United States in the region. Conversely, Nicaragua is at the moment one of the United States' most disliked countries in the region. And I think for both reasons, any effort, if Nicaragua were to make it, to seek some kind of enforcement would be doomed to failure because the U.S. would block it in the Security Council. I should say, just for completeness and underscoring good news, Colombia's reaction to the recent decision of the court in the violations case has been somewhat more tempered. And so I think there's still, over the long term, some possibility that the situation will move more in the direction of compliance than was previously the case. So there's reason to be hopeful there, actually. In the Somalia-Kenya case, I think it's probably unfeasible because it requires a difficult political, coordinated political effort by, in this case, Somalia, to try and bring this up at the at the UN, in the Security Council, and sort of muster enough support and see anything through. And I think for very practical reasons for the time being, it's very difficult to see the Somali government, which has many other priorities at the moment, bringing the degree of focus and effort to bear necessary to see that happen. I think in any effort may also encounter difficulty because from a Western perspective, Kenya's very important to the security arrangements in that region. So it may be difficult to sustain, again, quote unquote, Western support for any such action, but that's just speculation. To the question about domestic political issues, I think I don't mean to be too dismissive of the political dynamics in either Colombia or Kenya, but if there were political issues, I sort of see them as being of those 2 governments making, and that could easily have been avoided. if they had taken a less strident, more open approach. But in both cases, before the fact, the governments, for their own political reasons, I'm sure, mustered or raised sort of domestic awareness of these issues to such a point that when they lost, they were confronted with a very difficult issue. I mean, ultimately, in Kenya's case, I think the problem really was an old boundary agreement with Tanzania that, when viewed in conjunction with an equidistance line with Somalia, looked like it could be relatively prejudicial. So Kenya was trying, in a sense, to compensate for that, disadvantageous agreement with its boundary claim as against Somalia. But again, rather than ever signaling that there was doubt or that its position was less than immovable, Kenya took the opposite approach and I think really whipped up domestic interest and anger in this issue when it didn't need to do that. It could have taken a very different approach. So if there was a political problem, I view it as of its own making.
Right, thank you for those questions. James, yours is a point I hadn't thought about, whether my framework on legal statecraft is limited to small state greater power disputes or whether it has a wider application. I'd say it probably does have a wider application. I came to the question because I was intrigued by the idea that we have this literature around lawfare and strategic litigation that largely looks at the use by non-state actors of international law means against states, and that same interest in the power disparity hadn't been applied to the case of small state litigation. I can see that the framework might apply more generally, but I'd still say that the unique feature is that if we're thinking in terms of the ordinary political science definition of statecraft, the use of the instruments of power that a state has available to achieve its national objectives, the legal instrument looms a lot larger for very small states because it's often all they've got, right? And as international lawyers, that's something in a sense that we should be proud of, the formal legal equality of states and the fact that that can make a genuine difference to international affairs. On Don's question about what influence did the award in the South China Sea play in Australia's change of heart about the approach it would take to the Timor-Leste issue, I haven't yet done all the work I need to do. In fact, I've barely started on the Timor-Leste case. My sense is that there was, as there often is in these situations, a confluence of factors involving civil society, the legal issues, and, as you say, the question of the South China Sea Award, in the sense that around the same time, Australia's defence and strategic policy documents started talking more often and more robustly about the need to uphold the rules-based order in the maritime domain. And as you point out, it's rather hard to do that and make arguments about what should be taken from the South China Sea Award if you're seen as playing fast and loose and unfairly with as disadvantaged a state as Timor-Leste. I'd also say, just piggybacking in on Larry's comments about the domestic politics implications. I mean, there's obviously been a lot written about this, right? And the fact that often international adjudication should be the way out of domestic politics because you can say, well, there's nothing we could do. The international court held against us and that's how we're going to bury the political issue. But also I think what we see in the South China Sea case is something slightly different where parties' positions have been in a sense frozen, or where compromise is much less likely as a result of the award, and that's not necessarily a bad thing. So you have a kind of maritime nationalism where it's now very difficult for Vietnam or the Philippines to be seen to give anything up in terms of their EEZ because of the internal backlash they would face. But Is that a bad thing? As lawyers, we're always very focused on dispute resolution, but sometimes, the maintenance of a dispute in its present bounds, if the alternative is unjust compromise, might not be a bad outcome.
Thank you very much for the question to the discussant. I think it's a very rare opportunity for answer the question from the floor as a discussant. To my best knowledge, I don't think there is any official position about the non-appearance and non-compliance about the international proceeding by the Korean government. But there are some scholarly writings after the Nicaragua judgment in 1986, and also South China Sea Arbitral Award. There are some research articles which are criticizing the United States and China as not appearing before the international proceedings. And also, I would like to add, in my own opinion, I'd like to, I believe that Korean government, as a law-abiding nations which are upholding the promoting of international law and rule of law in international society, I think we will join the proceedings if there is some compulsory procedure war initiated against the South Korean government. But unfortunately, 2006 April, South Korean government made a declaration to exclude optional exception to the maritime boundary limitation and also military activities and Security Council Chapter 7 dispute. So I don't think there will be it is not highly likely that there are compulsory proceeding against South Korean government. But if there is any international proceedings initiated, I believe that our government will be very actively engaged. And it also contributes to the promoting our national interests as well when we're considering the ongoing cases, the Ukraine versus Russia. I was a little bit surprised that Russia was very actively engaged in coastal rights arbitration in the very early stages. They want to make some litigation strategy to make some kind of a preliminary objection, not to get the high attention from the world public opinion, like the South China Sea arbitration. So it gave us some lesson to the Russia. So I think most of the country will have to learn about the lesson. Thank you.
Thank you very much, Wonhee. And given there are no more questions from the floor, I think it's probably time to wrap up this panel, and hopefully nobody will grumble at having a few extra minutes for coffee break in the afternoon. But to close things off, can I just thank our three panelists again, our two presenters, Mr. Larry Martin, Professor Douglas Guilfoyle, and our admirable commentator, Dr. Wonhee Kim, who has stepped up to the challenge of being the sole commentator on this panel and has done it very well. So thank you very much to all involved.
Thank you very much, Professor Harrison, especially to moderate this session perfectly. And thank you to all our panelists up on the floor. Let's give them a big round of applause once again.